Well, welcome everyone. I think I know most of the people, actually I know everybody in this room, but just very quickly, tonight's presentation is part of our ongoing series in integrity governance training for the board and for the public benefit. My name is Martin Sahovich. I am the Master of Arms for the Weirton Area Port Authority. As part of my responsibilities, I develop training for the board, and again, wherever possible, allowing or encouraging the public to attend for public benefit. Introductions, let's start off. Let's see here, we have Chairman of the Board, DJ DeFelice is here. We have Board Member Farley Wood is here. Board Member Bethany Goddard is here. There's some other honored guests, Captain Bob Shima here of Robert Hill and Associates. Rod Young with Great Plains. Mr. Mogan from Hellman Worldwide. We have MJ Johnson with the Office of the Executive Director. Jimmy Grieco with the Weirton Area Wink. We have Dan Brennan over there with Reserve Capital, Financial Advisor. Les is here tonight. Miss anyone else? And the illustrious Carl Keffer, Executive Director of the Weirton Area Port Authority. The central tenet of this training series is that knowledge through training can lead to better government. Our objective, our purpose in this training is to provide tools so that our elected and appointed officials can do a better job, more informed job of executing their duties. Tonight we have two topics that we'll be covering, two sets of standards. One is ethics in government, and again this applies particularly in this case to the West Virginia Government Ethics Act and its application to government employees as well as appointed officials. So there'll be one area that we'll be discussing, and we have prepared slides and also prepared video from the West Virginia Ethics Commission in this area. And the second topic for tonight also is the West Virginia Open Meeting Standard, sometimes known as the Sunshine Law, also known as the Open Governmental Meetings Act. So tonight is training on standards. As part of tonight also, I would also have my PowerPoint here. My objective is to try to tie these standards together as they relate to the board. So please bear with me for a few slides as we get into this. Next slide, please. Definition of ethics. We can have a very elaborate or very simple, straightforward definition, and decided to go with the straight and short here. Moral principles that govern a person or a group's behavior. One simple definition. And the other definition, branch of knowledge, also known as a branch of philosophy, that deals with moral principles and the systematic vending, defining type of area. And often synonymous with ethics are such concepts as a moral code, values, rights versus wrongs, principles, ideals, value systems, and dictates of conscience. Going forward with this area, I mean, it's very easy, as you and I know, in terms of ethics, to get very philosophical, very general, very tough. In some cases, from expediency, we try to ignore the area of ethics. And one of the things that I found through some of my research was that, in contrast, there are some who believe that ethics is a very straightforward, can be a very practical, straightforward standard in our lives. In this case, one of the author, business writer John C. Maxwell, in his book Ethics 101, which, again, obviously, for keeping it simple, it's obviously a very big, voluminous tome here. But he defines or believes that ethics, the important thing is to avoid the complexity, to use one guideline to govern all of our ethical decisions versus, for example, if you looked at the definition of ethics in Wikipedia, it will define all kinds of different branches of discussion in this area. His argument is there should be one. Your life should be defined or guided by it. And that one guideline that he uses is based on the golden rule. So you ask the question, how would I like to be treated in this situation? As an integral guideline for any situation. John, in his book, basically was kind of given a challenge back early, about 2000, with the president of the publishing division of Time Warner, who asked him to look at this topic, given its significance at that point in time. And I guess looking at everything he saw, that he felt that a very simple, straightforward approach had the most practical value for us in business and government and other areas. And then, as he defines it, and I think we see this in our own lives every day, there are really only, according to him, only really two important points when it comes to ethics. First is the standard that we follow, and the second is the will to follow it. Tonight we'll be talking about those standards. Next slide, please. And I think one of the other areas you'll see in the video coming forward here, setting the standards of ethics, the organizational aspects that you'll see tonight. First is the area of culture. I learned out of college that by looking at and observing the leadership, one can very, very quickly determine the true culture of an organization. If its leadership has high values, the organization reflects that. If an organization has low values, you will also very, very easily see that as well. So culture of leadership defines that organization. To effectively instill standards such as ethics, training is required. There's also independent review through audit of the processes within the organization. It's typically done by an outside agency. In this case, for example, the state of West Virginia has its West Virginia Ethics Commission. Investigation means are provided in the case of allegations of any kind of wrongdoing. The Ethics Commission of West Virginia does in fact provide that service across the state. And an area of management control, again, leadership, effectively setting standards and also expecting their enforcement. In this presentation tonight, the video that you'll see, you'll have a couple of slides that will tie very closely to some of our developments within the board resolution, in this case 105, for confidential information. So when you see that slide, remember the recent development within the board of the insider trading material information policy is very, very appropriate or very closely aligned here. When you see the discussions of voting from the state, this is related to the issue of any related party type situation which friend, family member, where you are to recuse yourself as a government official from any kind of decision making in terms of hiring or awarding of contracts and things of this nature. So again, when you see some of these slides, you'll see that, or in the video that's coming. And then finally, obviously, the issue of ethics policy in general, our board resolution development of a code of standards policy, in this case, board resolution number 78. And now, the show.
Hello, my name is Kim Weber, and thank you for joining me today to learn about the West Virginia Governmental Ethics Act. Let's get started. Historical background. The West Virginia Ethics Commission was enacted 25 years ago during a special session of the legislature. That session created the Ethics Commission and passed the West Virginia Ethics Act, codified in West Virginia Code, Chapter 6B. Governmental Ethics General Principles, West Virginia Code 6B-1-2. First, to maintain confidence in the integrity and impartiality of the governmental process. And second, public employees should avoid conflicts between their personal interests and their public responsibilities. The Ethics Act applies to public servants in state, county, and municipal government, the executive, legislative, and judicial branches, all elected and appointed officials, both full and part-time employees. The Ethics Act does not apply to contractors or private organizations receiving government funds. In 1989, Governor Caperton called upon the legislature to enact an Ethics Act to help enhance the reputation of West Virginia. We at the Ethics Commission are dedicated to furthering this mission. West Virginia Ethics Agency mission: informally advise public servants, formally advise with advisory opinions, investigate and prosecute complaints, and train and educate. Topics covered by the Ethics Act. First, private gain, public contracts, gifts and solicitations, confidential information, employment restrictions, and last, voting. We'll begin with the use of office for private gain, which is codified in Code Section 6B-2-5B. And the principle is that you may not, as public officials, use public resources, including your title or subordinate staff, for personal benefit. That's either to yourself or to another. The Ethics Act prohibits more than a de minimis use for personal purposes. The question becomes, what is de minimis use? And if we use any amount of public resources, we risk crossing that line and violating the Ethics Act. For example, taking a few paper clips home with you, of course, would not be a violation of the Ethics Act. But taking a carton of paper clips home with you just might be. Next, I'm going to talk about nepotism. Nepotism in the media is a very hot subject, and that is why you need to take extra care in following all of the nepotism guidelines to their fullest. Nepotism. Rule 158, West Virginia, State Rule 6.3. When hiring a relative, cohabitating partner, roommate, or close friend, the public should be given reasonable notice. The notice should include a description of the job responsibilities, the qualifications required, the pay, and the method of application. The notice must give interested parties the timely chance to apply. If possible, the public official or employee should stay out of the process. If he or she is one of several people with hiring authority, others should make the selection. An independent person should take part in the selection. He or she should avoid using a subordinate as an independent person. And if he or she must share in the decision, he or she should use his or her best objective judgment in making the selection and be prepared to justify the selection. County nepotism. West Virginia Code, Section 61-10-15. Prohibits employment of dependent family members, spouse or dependent children, etc., of county officials who have voice, influence, or control over hiring process. Cannot simply step out of process. A spouse may be employed, however, in the same agency if they were not engaged or married at the time of the spouse's hiring. There are exceptions. The county nepotism exceptions. County official may be employed by a vendor under certain circumstances. A county official may have a pecuniary interest in a public utility or a bank where the county deposits its funds. Again, under certain circumstances. And a spouse of a county official may work for a county health care agency. And again, a spouse of a county official may work for the same agency if not married or engaged before taking office. And please note that there are restrictions, e.g., affected county official must recuse him or herself and may not supervise the related employee. Next, we'll talk about prohibited interests in public contracts, codified in Code Section 6B-2-5D. First, elected public officials and employees may not have a financial interest in a public contract under their authority or control. There is a $1,000 threshold, above which it is prohibited. This includes almost all financial transactions. For example, purchases, leases, sales, grants, except employment contracts. Employment contracts are covered under the previous topic of nepotism. Also, the Ethics Commission has discretion to grant an exemption to a public entity based upon undue hardship or excessive cost. Other exceptions to prohibited interests in public contracts. Members of the legislature may contract with any government agency, but may not use his or her prestige of position to secure a contract. Finally, a part-time appointed official is not subject to the prohibition, but he or she must recuse herself if a conflict arises. Prohibited interest in public contracts, West Virginia Code Section 61-10-15. Certain county officials may not have a financial interest in any amount in a public contract over which their public position gives them any voice, influence, or control. Again, the Ethics Commission has grant hardship waivers. We see these contract provisions coming up frequently at the Ethics Commission. One common scenario is when a city council member in a small town would like to do business with the town. And usually this is because there's nobody else in the vicinity that can provide this service. If this occurs, the town itself must request for a contract exemption with the Ethics Commission. Another place where we see the contract provisions come into play is at the county level. And as I pointed out, there is a separate statute, 61-10-15, which holds certain county officials to even a stricter standard than the Ethics Act. And that standard, for example, would be if a county commissioner wishes to do business with the sheriff's department, he would be prohibited to do so. And the reason is that a county commissioner has voice, influence, or control over the sheriff's department's budget. So even though the commissioner is removed by a whole level of authority, that is the sheriff, the county commissioner still may not do business with the sheriff's department. Now we'll talk about gifts. The general gift rules are codified in West Virginia Code 6B-2-5C. Solicitation of gifts from an interested party is prohibited. Don't accept a gift with a fair market value over $25 per year from an interested party. No limitation on food and beverages, so long as the person providing it or its representative is present. The next question then is, who is an interested person? The Ethics Act defines interested person as one who seeks or does business with the public servant's agency, is engaged in activities regulated or controlled by the agency, or has financial interests which may be substantially and materially affected in a manner distinguishable from the public generally by the performance or non-performance of official duties. Never solicit from lobbyists. Public officials may not solicit lobbyists, even for food, beverages, or other gifts. There is an exception. It is the charitable solicitations exception. Gifts may only be solicited for a charitable purpose, such as the United Way. But still, limitations apply. Government officials may not solicit contributions from a subordinate. This year, the Ethics Commission issued an opinion, Advisory Opinion 2014-16, which thoroughly discussed the limitations of fundraising and soliciting and even selling commercial products at the office. In short, these activities can occur. However, there are strict limitations. Please consult this advisory opinion if any of these activities are proposed in your office. Public Employee Recognition Guidelines. Public funds may be used to purchase light refreshments, meals, mementos of appreciation. We may spend up to $25 per employee per fiscal year. For example, if there are 10 employees, then the office may spend $250 in public funds. This may be allocated between employee recognition events, and public officials may spend up to $100 on one employee and less than $25 on others. A similar topic concerns retirement gifts and events guidelines. And these apply to public servants who are retiring from public service, transferring to another public agency, resigning to return to private sector, or completing their last term of office. The general rule is that we may spend up to $100 of public funds to purchase a plaque or other commemorative item. We may not give money or a gift card as a gift, but rather only a commemorative item, such as an engraved clock. More about retirement gifts and event guidelines. Absent specific legislative authority, we may not spend public funds to pay for meals, food, or beverages at an event recognizing a departing public servant. Any meals, food, or beverages must be purchased using private funds collected in accordance with guideline. We may not use public funds to underwrite any rental or related fees associated with the event held at an off-site location. Door prizes, gifts, and conference giveaways. In our public positions, we often attend and even host such events. There are rules to follow. A public agency may not use public funds to purchase door prizes, gifts, or giveaways. A public agency may use a reasonable amount of public funds to purchase the following: items such as tote bags, pens, pencils, or sticky notes to provide to conference attendees, and incentives and items to encourage audience participation. Please note that the fair market value of all such items provided to each participant may not exceed $25. For public servants who are attending a conference, we may only accept items valued at $25 in one calendar year. Prizes valued above $25 must either be returned, donated to charity, or donated to the agency. Panelist or speaker may accept travel, food, and lodging expenses, may also accept costs for one guest, may have an overnight stay, but it must be based on business necessity. And these guidelines are similar to the requirements for federal tax write-offs. Educational seminar. We may accept reduced rates or have a third party pay for it if the seminar meets a 5-part test which establishes that ultimate benefit is to the agency and not to the individual employee. Public employees need permission from their agency head and appointed public officials permission from governing bodies. Beware of receiving perks which are not part of the standard hotel package, such as golf and spa packages. Third party may not pay the cost of a guest if you are merely attending an educational seminar. Free tickets for sporting events. There are stricter limits. Tickets must be $25 or less and may not take a guest if the total value of all tickets exceeds $25. For sporting events, if someone plays a ceremonial role, for example, a mayor throwing out the first pitch of a city baseball game, the $25 limit does not apply. And the mayor may accept a ticket for a guest. However, this is a very limited exception, so please call on us first. Free tickets to charitable, cultural, or political events. The $25 limit does not apply if public officials are customarily invited and the tickets come from the event sponsor. And the public official may also accept a ticket for one guest. So, taking these principles together, a public official who actually participates in an event is allowed to accept gifts greater than $25. However, for public officials who are merely attending an educational seminar or other event, the gift limit of $25 applies. So please, if you remember one thing about this provision, please consider the $25 gift limit. And if you are offered a gift in excess of $25, please consider calling our office for further guidance. Next, we have a provision concerning confidential information, which reads, no present or former public official or employee may disclose confidential information acquired in the course of his or her official duties, or use that information to further his or her personal interest or the interests of another person. The improper disclosure of confidential information is a criminal misdemeanor. Next, we're going to move on to the subject of prohibited representation, which is codified in Chapter 6B-2-5F. No present or former public official or public employee shall represent a client in a matter in which he or she personally participated in a decision-making, advisory, or staff support capacity. The Ethics Act contains employment restrictions. Public employees may not seek employment with any person who had a matter on which they or their subordinate took regulatory action within the past 12 months, or currently has a matter before their agency on which they or a subordinate is working. For example, a health inspector of restaurants may not seek employment with such restaurants. There is a provision in the Ethics Act which allows the Commission to grant a waiver upon a showing of hardship. Further, for public officials, for some public officials, there is a 1-year revolving door or a 1-year waiting period, which applies to elected and appointed officials and full-time attorneys and accountants. When this applies, that official may not appear before the agency for a 1-year period. Outside employment. Secondary employment may not conflict with your current employment. You must work on your own time. You may not get paid for something that is part of your public job duties. And you need to consult with your supervisor to ensure compliance with agency rules, which may be more strict than the Ethics Act guidelines. You may not work for someone you personally or a subordinate regulate or a vendor over whom you have control. And we have limitations on compensation. A public employee may not receive additional compensation from another publicly funded state, county, or municipal office or employer for working the same hours. So, as an example of prohibited subsequent employment, if I or a subordinate attorney in my office prosecuted a public official, I could not leave the Ethics Commission and turn around and represent that same public official at the Ethics Commission in the same manner. Conversely, after waiting 1 year, I could return and represent public officials in front of the Ethics Commission. Next, we're going to talk about voting. The general rules of voting. First, do not vote if you or someone with whom you have a financial relationship has a financial interest in the result of the vote. And second, do not vote on a personnel matter involving your relative. For example, their spouse, sibling, grandchild, or even the in-laws. And please note that you need not have a financial interest in any of these relatives. Regardless of your financial connection, you do not vote on personnel matters concerning them. More about voting. Public servants may not vote to award a contract to themselves, a business with which they or a spouse or dependent immediate family member is associated. Please notice the word dependent when we're dealing with contracts. Businesses with which they are associated means a business of which the person or an immediate family member is a director, officer, owner, even employee, compensated agent, or holder of stock, which constitutes 5% or more of the total outstanding stock of any class. Proper recusal. A public servant who is required to recuse himself or herself must, first, fully disclose his or her interest. Second, leave the room during both the discussion of and vote on the issue. And the minutes must reflect the recusal. Enforcement. The Ethics Commission enforces the Ethics Act through the complaint process. Complaints and sanctions. Any citizen may file a complaint. Complaints must be verified. The complaints must be filed within 2 years of the last act of alleged misconduct. The Ethics Commission may initiate complaints based on credible evidence that a material violation has occurred. And complaints must allege violations of the Ethics Act. Oftentimes, the Ethics Commission will receive complaints that don't fall under its jurisdiction. For example, the Commission receives complaints of certain behavior that some feel to be unbecoming, such as appearing drunk in public or speeding down the highway, or even allegations of more serious offenses that are committed during one's private time. These allegations don't fall within the jurisdiction of the Ethics Act, but rather allegations have to be based upon specific provisions, the provisions that we've been discussing here today. Complaints and sanctions. The complaints are brought before the Probable Cause Review Board to determine if there is probable cause to issue a notice of investigation or the complaint should be dismissed. Once the notice is issued, the Ethics Commission staff investigates the allegation. And if the allegation has merit, the Probable Cause Review Board issues a statement of charges to the respondent, and the process continues through the public hearing stage. Potential sanctions include a public reprimand, cease and desist orders, orders of restitution for money, things of value, or services taken, fines not to exceed $5,000 per violation, and reimbursement to the Ethics Commission for costs of investigation and prosecution, and a recommendation that a respondent or public official be terminated from employment or removed from office. Please note that the Ethics Commission does not have authority to remove a public official from office, but rather to recommend removal from office. Next, I'd like to talk about advisory opinions, which are issued by the Ethics Commission. And these opinions are taken up and discussed and approved in a public meeting. The identity of the requester and its agency is kept confidential. And a public official who relies upon an advisory opinion receives immunity for conduct in good faith reliance on the advisory opinion. Thank you for attending this training. We at the Ethics Commission are committed to helping you comply with the Ethics Act, so please feel free to contact our office with any questions or concerns you might have. We are here to help public officials comply with the Ethics Act. We can be reached at the Ethics Commission by phone, email, and fax. We also have a website, www.ethics.wv.gov, where you can learn valuable information about complying with the Ethics Act. Thanks again.
We have the second video, so we're going to switch over that, and I have the rest of some slides I wanted to highlight a few areas on the next slide.
Oh, it's here. There it is.
Jay, can you go to the next one?
Okay. You want the next slide?
Yeah, that's please.
Got it.
Next, please. A couple of points that I wanted to highlight before we go into this video. Real quick, important for the public, the concept of right to witness. The public has the right to witness the deliberations of meetings of government bodies such as the Weirton Area Port Authority. It does not give the public the right to participate, although we allow question and answers. It also does not allow the right to disrupt any of those meetings. They have the right only under law to, in fact, witness the deliberations. Next slide, please. What constitutes a valid meeting? And this is an important area for the board and for people in general. First off, sufficient advance notice, defined at least by 5 business days, has to be reported in the West Virginia State Secretary of State website, which we do, as well as the public announcements that we put out. Detailed agenda, you cannot just have an agenda that says new business, old business, that type of thing. You must provide details about what's going to be discussed in the upcoming meeting. Quorum of the governing body must be present. In our case, 6 members, so at least a minimum of 4 must be present. Intent to deliberate on policy matters or issues. This is very, very significant. If a board, for example, was invited to a barbecue and attends that barbecue and has no discussions about anything, any deliberations related to that entity, there is certainly no meeting has occurred. However, in that context, if there was any discussions and deliberations, that would in fact be a violation of the Open Governmental Act. The public has the right to witness the deliberations of the body. So just to make sure you understand that, in fact, again, at that point, the public must be present for all deliberations. There is the option of something called the executive session. We'll cover that real quickly here. And the other point of it is that all voting related to deliberations of that council have to be held in public. They have to be witnessed by the public. And published minutes as well, typically within 24 hours. Executive session, valid use of deliberations include personnel matters, pending litigation, matters concerning the purchase, sale, or lease of real property, and official investigations. So areas that are of a sensitive nature. These are not open to the public. They are not subject to any kind of published minutes. But most importantly, no voting is allowed during an executive session. And now part 2 of the show.
Hello, my name is Kim Weber, and I serve as General Counsel to the West Virginia Ethics Commission. I've been a member of the State Bar in West Virginia since 1995, and have been an attorney for the Ethics Commission since 2010. On behalf of the Ethics Commission, I welcome and thank you for attending our training on the West Virginia Open Governmental Proceedings Act. This training is helpful to government officials, both elected and appointed, who are voting members of a public body. And this training is also helpful for public employees who participate in making agendas and recording minutes for these public meetings. Let's get started. Topics covered by the Open Meetings Act. The definition of meeting exceptions to having open meetings, notice of meetings, agenda for meetings, meeting procedures, meeting minutes, and violations. Historical background. The Open Governmental Proceedings Act, or the Open Meetings Act, is also known as the Sunshine Act, which was enacted in 1975. It applies to state, county, and municipal administrative and legislative bodies. They are subject to the Act, as well as any bodies that meet the definition of public agency. What is a meeting? A meeting is defined by the Act as the convening of a governing body of a public agency for which a quorum is required in order to make or deliberate toward a decision on a matter which results or will result in official action. The definition of official action is important. It is defined in the Act as action which is taken by virtue of power granted by law, ordinance, policy, rule, or by virtue of the office held. There are different types of public meetings. A regular meeting, which is a scheduled gathering of a governing body. A special meeting, or irregular meeting, called for something less than an emergency. And last, an emergency meeting. Emergency meetings are newly defined in the Ethics Act, and you can find information about them in West Virginia Code 6-9A-22. An emergency meeting is any meeting called by a governing body to address an unexpected event requiring immediate attention because of imminent threat to public safety or health, imminent threat of damage to public or private property, imminent material financial loss or other imminent substantial harm to a public agency, its employees, or the members of the public which it serves. The Open Meetings Act applies to all public agencies, their committees, and even their subcommittees. It also applies to commissions and boards and bodies that represent boards of medicine and accountancy and nursing and other boards that are required to exist by state code. Conversely, private, nonprofit organizations are not typically subject to the Open Meetings Act, even if they receive substantial governmental funding. So there are three types of meetings, and they're treated differently under the Act. The regular meetings are the most common, and these are typically your monthly meetings, say of City Council, or a quarterly meeting of a committee of City Council, things that are anticipated and regularly held and set. And at these meetings, the normal course of business takes place, business that has to be approved by the governing body. So for example, paying bills or entering into contracts or voting on budgetary issues. Those things are typically done on a regular basis at a regular meeting. There are also special meetings, and these occur less frequently. When things come up between the regularly scheduled meetings that really need to be addressed before the next meeting, then a special meeting is in order. And for example, perhaps a town employee realizes between meetings that there's a grant application or acceptance rather that needs to be approved by City Council imminently. The deadline is before the next regular meeting. In that event, the city should hold a special meeting, which requires less notice, so that they can take up the issue of approving the acceptance of the grant. And last are emergency meetings, which we've talked about. and they are really very rare. They're not intended to be taken up lightly. There are exceptions to the definition of meetings that must be held in the open. The first is an adjudicatory session, and an example would be a disciplinary hearing. Another exception is an on-site inspection, for example, to visit a construction site. And third, political party caucus. More exceptions. General discussions, whether they're planned or unplanned, social, educational, training, informal, ceremonial, or similar settings. So long as they are without the intent to conduct public business, and there's no intention for the discussion to lead to an official action. More about general discussions. The general discussion exception is most difficult to follow. Some guidelines. If discussion is about something that will lead to official action, either right then or at a later time, the meeting must be noticed. It does not prevent a quorum of members of the governing body from going to the mayor's house for a barbecue, for example. It does prevent a quorum of members of the governing body from going to the mayor's house for a barbecue and a discussion about the new budget. From the last slides, we see that not all gatherings are subject to the Open Meetings Act. In fact, the legislature specifically recognizes this in the act itself. It states that it would be unrealistic, if not impossible, to conduct all governmental business in public. So, the goal of the Open Meetings Act is to balance the interests of allowing the public to meaningfully observe and participate in decision-making and the efficient running of government business. Now remember, when deciding whether something needs to be conducted in the open, there are two elements to consider. One, is there a meeting of a quorum of the public body? And two, is the meeting for the purpose of official action that will be taken or will ever be taken, even at a later meeting? So if there is a quorum and the purpose of getting together is to take official action, then absent an exception, that meeting is subject to the Open Meetings Act. Now there are exceptions, and I've mentioned some. An example of an adjudicatory session would be a city civil service board for a police or fire department. These boards meet to take up disciplinary issues and grievances that officers might present or the public. And these are called adjudicatory, and they are not subject to the open meetings rules. Even though official action will be taken at these meetings, they still, because they're adjudicatory, are not subject to the requirements. I also mentioned on-site inspections. And for example, if the 3 county commissioners of a county want to travel to visit a parking garage in a neighboring county because the county wants to build one of its own, it could do this without noticing a public meeting. The members would just need to be careful not to have a discussion or deliberation while they're viewing the garage itself. They need to look for facts. They can talk to different people who know things, but they cannot deliberate together among themselves outside of the public meeting. Notice and agenda. The Open Meetings Act requires advance notice of the date, time, and place of the meeting, including any committee meeting, and an agenda of all matters to be considered and/or discussed. Meeting agenda. Regular meeting agendas must be made available 3 business days in advance of the meeting. Special meeting agendas must be made available 2 business days in advance. The agenda must be made available at the organization's place of business by close of the business day on the first notice day. Emergency meetings, notice agenda, and minutes. There are special rules for emergency meetings. A notice for an emergency meeting must be posted as soon as practical before the meeting. Notice must give the reason for and purpose of the emergency meeting. Governing bodies that wish to add emergency matters to their meeting agenda must post an amended agenda, which includes the emergency item. This is to be done as soon as practical. The amended agenda and the meeting minutes must further explain the facts and circumstances which warrant adding the emergency item to the agenda. Now, there are additional requirements for state agencies. State agencies must also file a notice of any meeting with the West Virginia Secretary of State's office for publication in the state register at least 5 business days prior to the meeting. Meeting agenda is a list of all items requiring official action on the agenda. Official action involves anything requiring a vote of the governing body, either at this meeting or at a future meeting. Meeting agenda. Agendas must give reasonable notice to the public of every issue to be discussed. Items must be specific enough to put the public on notice of intended action. Vague headings are insufficient. Some examples of vague headings: simply writing old business or new business. Simply writing the word personnel is also too vague a description. Instead, use entries like filling position of office manager or open sealed bids for XYZ project. Agendas need not be published, not in the newspaper, not on a website. They need only be made available to the public. Including the agenda on the agency's website is recommended, but may not be the only method of posting used. Posting in a public place meets the minimum requirements of the Act. Amending an agenda. The agenda may be amended up to 2 business days before the meeting. The amended agenda must be made available to the public and media in the same manner as the original agenda. The only circumstance under which the agenda may be amended during a meeting is if an emergency arises. Routine matters that arise after the deadline to amend an agenda must be held over to the next regular meeting or for a special meeting. If an agenda is amended due to an emergency, both the meeting agenda and the meeting minutes must explain the facts and circumstances of the emergency. Remember, the principle behind the notice and agenda is transparency. The public must be put on notice of what will be taken up at your meetings. So, I will use the Ethics Commission for an example as to how we supply notice and an agenda of our meetings. Because the Ethics Commission is a state agency, it must provide notice to the Secretary of State's office of both its regular and special meetings. The Secretary of State must register it in the state registrar, which must run for at least 5 days prior to the public meeting. The substance of the notice is very simple. It is only the date, time, and place of a regular or special meeting. At the Ethics Commission, we also post our notice on the bulletin board next to the entrance to our offices. As for the agenda, If it's a regular meeting, at least 3 days before the meeting, our staff posts a detailed agenda, also on the bulletin board. And this meets the requirements of the Act. At the Ethics Commission, we also post our notices and agenda on our website, although this is over and above what is required by the Act. A word or two about counting the days for your notice. Notice is considered accomplished if you get the notice submitted by the end of the business day. However, the day of the meeting cannot be counted in your notice period. So for example, if you post your agenda on a Thursday by 5 o'clock, that Thursday counts as your first day's notice. If 5 days notice is required, then the meeting can be held on the following Thursday. Next, we'll discuss meeting procedures. Members may participate by telephone, Skype, or other forms of electronic media. Members participating electronically and members present physically must be able to hear each other. Public present at the meetings must be able to hear what is said by all participating members. Voting. Voting may not be done by secret or written ballot. May not vote by text message. Voting must take place by verbal statement or show of hands. No proxy voting is allowed unless authorized by a governing body's enabling legislation. Robert's Rules of Order. They do not trump, supersede, or replace the Open Meetings Act. They may supplement the Open Meetings Act. Robert's Rules of Order provide guidance on parliamentary procedure during a meeting. They are not a substitute for state law. The Open Meetings Act is a state law that requires government entities to perform certain conduct before, during, and after a meeting. Executive sessions. Executive sessions are also known as closed sessions. And there are specific reasons for which government officials may enter into executive session. You may only go into executive session for a reason permitted by the Open Meetings Act. There must be a corresponding agenda item, and the motion to go into executive session must identify the reason for entering the closed session. Last, a majority vote is required. Executive sessions, the reasons for executive sessions. Executive sessions are most commonly called in order to discuss personnel situations. Matters pertaining to the hiring, firing, promoting, transfer, discipline, or compensation of an employee or official are appropriate reasons to enter into executive or closed session. If an employee or official requests an open session, the governing body must grant the request. Executive session. General personnel matters are not exempt and must be discussed in open meeting. Examples of general personnel matters: across-the-board pay raise, supplemental health insurance, creating new positions, adopting personnel policy. Other reasons for executive session: security, to plan or consider an investigation relating to crime prevention or law enforcement. Adverse effects on agency interests, for example, advanced construction planning, investment of public funds, and any other commercial competition. In order to permissibly move to executive session, the matter has to adversely affect financial or other interests of a political subdivision. More reasons for executive session. Attorney-client privilege. You may discuss attorney-client matters in executive or closed session, but you may not go into executive session just because an attorney is present. More about the attorney-client privilege. You may meet in executive session to approve or consider a settlement in a lawsuit. Settlement terms should be voted on in the public session and included in the minutes. More about attorney-client privilege. Litigation-related matters must still be placed on the agenda. Agenda items still must put the public on notice of the nature of the matter being discussed, even if it will be discussed in closed session. For example, discuss pending lawsuit of Smith v. Jones with counsel is sufficient, but not discuss pending litigation or discuss legal matters. Those entries are too vague. Warning, do not enter executive session to discuss agenda item A and then discuss either agenda item X or item not on agenda. The governing body may not vote in executive session. They may only deliberate there. Be wary of conducting more business than necessary in executive session. It creates a negative public perception of the meeting as being behind closed doors. Remember, executive sessions are the exception to the rule. Most deliberations that will lead to official action are to be done in an open session. If you anticipate the need, when you're preparing your agenda, to go into an executive session, please go to our website and learn more about the proper way to do it, or consult your agency attorney, or call us for help. And remember, even if you anticipate an executive session, you must still put the item on the agenda, and the public body must pass a motion to go into executive session. Random points about the Open Meetings Act. A gathering where a quorum of the governing body meets with staff is a meeting within the scope of the act. However, one member of the body meeting with staff is not governed by the act. General personnel matters must be discussed in an open meeting. Specific personnel matters may be discussed in executive session unless the subject wants an open meeting. Other privacy laws may apply and require an executive session. You should consult with your agency attorney if you have questions about that. Public comments. Public comment periods are recommended, but they are not mandatory. You may not require a speaker to sign up more than 15 minutes in advance. You may set time limits for speakers. If an item requires official action, it must be placed on the agenda for the next meeting, so the public is put on notice. Meeting minutes. Minutes are required for all meetings, including committee and subcommittee meetings, but not for the executive session portions. Meeting minutes must be made available within a reasonable time. Reasonable time has been defined by the Ethics Commission as close of business on the next business day following the next meeting, because the next meeting is where the minutes are approved. If there are material changes to the minutes, then the minutes should be available no later than 3 business days following the next meeting. Draft minutes are encouraged but not required to be made available for public inspection. Requirements of minutes. The Open Meetings Act specifies the information required to be in the minutes. The date, time, and place of the meeting, the name of each member of the governing body present and absent, all motions, proposals, resolutions, orders, ordinances, and measures proposed, the name of the person proposing the same, and their disposition, and the results of all votes. And upon the request of a member, pursuant to the rules, policies, or procedures of the governing board for recording roll call votes, the vote of each member by name. Violations. Intentional violations are a criminal misdemeanor, subject to prosecution by the county prosecutor and up to a $500 fine or a $1,000 fine for subsequent violations. Violators may also be liable to wronged parties in civil court. Last, a court may annul a vote taken in violation of the act. I hope you found this presentation to be helpful. Please visit the other resources on our website while you're here. You can also find information about how to comply with the Ethics Act, financial disclosure requirements, lobbyist registration requirements, and school board member eligibility. On behalf of the Ethics Commission, I thank you for attending today's training. We can be reached at 210 Brooks Street, Suite 300, Charleston, 25301. Our telephone is 304-558-0664. Our toll-free is 1-866-558-0664. Our website is www.ethics.wv.gov, and our email is ethics@wv.gov.
That concludes tonight's presentation. Thank you for coming. The slides from both the state as well as this introduction that I gave is up on our website if you want to download it at any point in time. Mark, again, thanks for coming.
That is really geared towards truly public agencies and departments and government. With us being a public-private, as far as the WAPA board goes, that would change some of the executive session requirements and allowances with it.
I think it'll be something that we'd have to look at collectively, and then there are certain issues we can talk to.
You're involving private entities, private for-profit companies for financial disclosures and things like that, that we wouldn't necessarily want to or have to make that public.
Correct.
So that would be something that would be.
I think they refer to it as personal matters
Okay.
for the executive session. But I think the intent of WAPA is not to divulge or discuss, even in executive session, private, the private affiliates, financial statuses or other, unless it directly affected the Weirton area.
And I guess the only other option would be if there were questions that could be directed towards the Ethics Commission, that's always an option.
Well, and we discussed that. We have discussed that. Is how to handle an omnibus discussion. And so, yeah, because it's a good question. I don't know that we have a definitive answer.
There was an out on there that said also other items that may be prevented from being in public by West Virginia Code, which intellectual property of private organizations can be found in various West Virginia codes is not a public display unless it's really tied into something for public. So I think there's an out for some of this stuff.
Well, again, thank you for coming.
Are we off the air?